give everyone a lot of stress when it comes to maintaining time. And thank you so much for sticking to time, of course, but we will have the Honorable Chief Justice of the Bombay High Court joining us in the next 10 to 15 minutes. So I'd request you all to, of course, please be seated, and we will inform you when he enters the premises. Thank you so much.
Thank you so much. So, may I please request Mr. Vikram Nankani, Senior Advocate and MCIA Council Member? Not yet. Okay, we wait for a few minutes till a few more people are seated. Thank you so much, ladies and gentlemen, and welcome again to our last session of the MCIA in Mumbai today. It is my pleasure to call to the podium Senior Advocate Mr. Vikram Nankani to introduce our keynote speaker for the evening. Please, sir.
Good evening. May I, on behalf of the Mumbai Centre of International Arbitration, extend a hearty welcome to the Honourable Chief Justice, Justice Upadhyaya, and other dignitaries whom I can see here, Justice Kamal Kata, Justice Arif Doctor, Justice Dr. Gokhale, Justice Dr. Deshpande, and other retired judges and retired Chief Justice of the Bombay High Court, Justice Shah. I have been assigned the pleasant task of introducing the Honourable Chief Justice, and for those who would not have already seen this, which is I have picked up partly from the public domain. I think the modesty of Chief Justice was that his office gave us a very, very short resume or a background of the Chief Justice, but I have the pleasant task of introducing him, and therefore I will do that. Born on 16 June 1965 in District Ambedkar Nagar, Uttar Pradesh, the Honourable Chief Justice had his education in Kovalam Talukdas College in Lucknow. He graduated in law in the year 1991 from Lucknow University and enrolled as an advocate on 11th May 1991 and joined the chambers of his father, Shri R.A. Upadhyaya, practicing at the Board of Revenues for the last 60 years. Shri Mohammad Arif Khan, Senior Advocate, Justice Mr. S.K. Kalia, Senior Advocate, and the Honourable Chief Justice practiced mainly in civil and constitutional matters at the High Court of Judicature at Allahabad at Lucknow. He was also the appointed as a Chief Standing Counsel for the state of Uttar Pradesh in May 2007 and continued to hold that office till elevation as a judge of the Honourable High Court of Allahabad. He was appointed as a judge of the Honorable High Court of Gujarat, Allahabad on 21st of November 2011 and took oath as a permanent judge on 6th August 2013. The Honorable Chief Justice became the senior judge of the Lucknow bench on 28th March 2023 until his elevation as the Chief Justice of our court, Mumbai High Court, on the 29th of July 2023. With these words, may I once again, Your Lordship, welcome the Honorable Chief Justice and will not come in the way of his keynote address. May I invite you, sir, to the...
A very good evening to all present here. The Chief Executive Officer of Mumbai Center for International Arbitration, its Registrar and Secretary General, Honorable Justice Mohit Shah, Justice Bhosle, the Chief Justices who has been my Chief Justice as well at Allahabad, my colleagues presently at Bombay High Court, other senior members of the bar, dignitaries present on this occasion today, all the participants in the ADR week, ladies and gentlemen. It gives me immense pleasure to be a part of India ADR week being organized by this center. I was going through the small booklet published by the center, which gives details about the procedure and practices which are being followed by the center while dealing with arbitrations. However, alternative dispute resolution is not confined to arbitration alone. Since it is an ADR week, therefore, apart from strengthening the arbitration, we need to talk about and discuss other ADR mechanisms such as mediation as well. It is widely acknowledged that India is not only an emerging economy, but is a leading country so far as economic and other related activities are concerned globally. As one of the fastest growing economies, India needs to find its way forward to create an environment where ease of doing business can be felt and realized by all stakeholders, be it the businessmen or the industrialists or entrepreneurs or startups or all those who intend to contribute to the overall growth of the country. To facilitate ease of doing business, our country needs to strengthen the dispute resolution systems, both in the adversarial system of adjudication of disputes as also in the fora which are alternative to adversarial system of administering justice and resolving the disputes. We have had a statutory regime for arbitration as an alternative dispute resolution mechanism since long. By enacting Arbitration and Conciliation Act 1996, the Central Legislature took a step forward to remodel the entire arbitration scenario in the country. Since in arbitration, resolution of disputes is by a third party, that is the arbitrator, who conducts an adjudication process and gives a verdict on the issue, the mode remains adversarial. In this process, the parties at dispute choose a neutral third party who conducts the process of adjudication and makes an award which is enforceable by a court. Though in the process the strict rules of evidence do not apply, however, exchange of pleadings and documents and examination of witnesses followed by award, and after the award is made, the same is challengeable in a court, albeit on limited grounds. Though the process of arbitration is less formal than what we find in a court, however, the process still remains adversarial, and our experience has been that as an alternative dispute resolution mechanism, the process of arbitration is yet to achieve the desired success in our country. The question as to whether arbitration after 1996 enactment has succeeded at all is being raised in the legal discourse of our country. It is this discourse which has given rise to the need of more and more institutional arbitrations. With the advent of liberalization of economy and globalization, which process had started in our country in early 1990s, footfall of global players in every walk of life in our country has enhanced manifolds and is increasing in geometrical progression. A lot of foreign direct investment is knocking the doors of our country. This trend, however, will not succeed in case industrialists and other players find our justice delivery system cumbersome. It is in this scenario that the institutional ADRs assume importance, and I hope that Mumbai Center for International Arbitration is an effort to fill the gap for providing a robust and effective ADR center. The term alternative dispute resolution encompasses in its fold every process of adjudication other than litigation. It includes arbitration, conciliation, mediation, and even a hybrid process of using both the arbitration and mediation simultaneously. It can safely be said that ADR is now becoming appropriate dispute resolution. However, on a lighter side, in some circles it is termed as alarming decrease in revenue. The lawyers have their own fears. Mediation in our country has a statutory backing now. Mediation Act 2023 has been passed to promote and facilitate mediation that lays emphasis on institutional mediation for resolution of disputes, not confined to commercial nature of disputes, but even the disputes otherwise. Now, this is a departure. In our country, the mediation has been viewed and it has worked not in any institutional form, but this enactment creates an environment, and I hope that mediation processes, as institutional mediation processes, will be strengthened by passage of this act, though this act has yet not been notified. But we are very near to that. The act talks about mediation agreement between the parties and also pre-litigation mediation. It also speaks about establishment and incorporation of a mediation council, which is to be known as Mediation Council of India, which is to be a body corporate. The Act of 2023 also provides for registration of mediated settlement agreement. This again is a very welcome move by the legislature. Such settlement is also enforceable under the Code of Civil Procedure as a judgment or decree passed by a court, as is the case with the arbitration awards. Such settlement agreement has been made challengeable under the Act on the grounds are very, very limited. The grounds are fraud, corruption, impersonation, or where mediation is conducted in disputes or matters which are not fit for mediation, as enlisted in the first schedule appended to this Act. The new statutory regime of mediation also provides for online mediation. The Mediation Council to be established under the Act will provide the manner of registration of mediators, as it has also laid down the standards of professional and ethical conduct of the mediators. Besides, the Council is saddled with the duty of developing India to be a robust center for domestic and international mediation, and also to hold trainings, workshops, and courses in the area of mediation in collaboration with all mediation service providers, law firms, academic institutions, and other stakeholders, both Indian and international. Mediation service providers are recognized by the Council, which are entrusted to perform certain functions, such as accreditation to mediators to provide all facilities, secretarial assistance, and infrastructure for efficient conduct of mediation and promote professional and ethical conduct amongst mediators. Now, this again is a departure from past practice which our country has been adopting in the area of mediation. This is a step forward perhaps for institutionalizing the mechanism of mediation. Thus, the Act of 2023, in my opinion, is a step towards creating an effective institutional mediation environment in the country. Another important feature of the new statutory mediation regime created by 2023 Act is community mediation. This is again a very important area where disputes which affect peace, harmony and tranquility amongst the residents of an area or locality may be settled through community mediation, of course, with the consent of the parties to the dispute. The entire scheme of the Act of 2023 is to create an environment where disputes not only between individual entities but also between public entities can be settled. With the special emphasis on institutional mediation, the 2023 legislation thus is a welcome step. As we all know, in advanced countries, disputes seldom go to court. In a study, it has been estimated that approximately 90% disputes arising in the United States of America get settled at a pre-litigation stage. I need not emphasize the benefits of ADR process as they are very well known. Before I conclude, I wish to speak a few words to the lawyers to allay the apprehensions from their mind. And the apprehension is that the process of mediation will affect the income of practicing lawyers. Lawyers, first of all, must know that the mediation is a new approach to dispute resolution, which lays emphasis on the mutual benefits of arriving at a consensus, rather than the need to defeat the other side, as happens in adversarial litigation system. What is the basic duty of a lawyer? If I may ask, his basic duty is to protect his client's interest. With the changing economic scenario, a lawyer must first of all acknowledge that mediation is a new method of dispute resolution, which is growing fast, and also that it is possible to act both as a mediator and a lawyer at the same time. He should also realize that the purpose of legal profession is conflict resolution, and thus the potential of mediation process in conflict resolution needs to be recognized by the lawyers. The legal practice by a lawyer can include representing his clients in mediation as well. Now, these are some of the thoughts which came to my mind yesterday only. There are a lot of apprehensions in the minds of the lawyers resorting to the process of mediation. Arbitration, of course, they have been representing the parties before the arbitrator, so that's not a problem. But mediation, it is generally thought that the dispute will be settled amongst the parties, then what will the lawyer do? So now, with the statutory regime introduced by the 2023 Act, with the emphasis on institutionalizing the mediation process in the country, we have the provisions for accreditation of the mediators. We have also the provisions for registering the mediation agreements and also registration of mediation settlement agreements as well for record. And it is now enforceable as a judgment and decree under the CPC. So these apprehensions should be allayed from the minds of the lawyers as well. Something about some practices in the arbitration which are not conducive to the whole environment. Now, in Uttar Pradesh, we come across many a times the arbitrations awards being directly challenged in a writ petition. Brother Justice Bhosle knows about. Now, what leads a litigant to challenge this arbitration award directly by instituting a proceeding under Article 226? What is happening is that there are various financial institutions, mostly the non-banking financial institutions, which put up a small kiosk in some small kasbahs, some very small cities, alluring the farmers to take loan for agricultural implements like tractor and other implements. Now, the poor farmer does not know as to what goes on in that loan agreement. That loan agreement contains an arbitration clause, the seat of arbitration being at Madras or Bombay. For a farmer to attend the arbitration proceedings either at Madras or Bombay from UP, in a remote area of UP, that's impossible. So then, if the arbitration process is undertaken by the NBFCs against such a poor farmer who does not know what exactly has gone into that agreement, loan agreement, then he seldom responds to the notices. It's very difficult for him to get involved himself with the entire arbitration process in this scenario. Then ex parte awards are passed, the orders are passed under section 17. When it comes to execution, then the award is sent to the district judge concerned in UP. Then once he receives notice, he feels he has been befooled utterly. So that's one of the practice which I wanted to flag today amongst the audience here. So these are some of the misuses also we have to be very cautious about. Why I laid so much of emphasis on mediation? There are certain benefits which are not available in case the dispute resolution is resorted to arbitration. Despite all our efforts, despite having a new statute in 1996, perhaps the question still remains whether we have succeeded in arbitration or not, whether it has served the purpose or not. As you are all aware, the purpose to take recourse to arbitration proceedings is to make the dispute resolution mechanism less cumbersome. But then again, there is an award, then section 34, then 37, then might be SLP. So that time which the arbitration proceedings generally take is very, very crucial to lay emphasis now on the mediation processes. That will be my message to all present here, because this center, I am told, is not confined to taking up the arbitration matters alone. So perhaps this new legislative regime, the new enactment which has been passed by the Parliament, once it is enforced, the emphasis of ADR is perhaps going to shift from arbitration to mediation. That is my hunch. So I would request this center to take up the mediations as well. Mediation, as you know, till now has been normally court annexed mediations. Wherever the references are made by the court to the mediators, either individually or in some high courts, some district courts also, we have trained mediators having obtained 40 years compulsory training as designed by the MCPC of the Supreme Court. But now we are going to have some kind of a mechanism where institutions like the center, this Mumbai Center for International Arbitration, that can act as a model to develop as an institutional mediation center in Bombay, which can be copied elsewhere as well. So to the CEO and the other office bearers of this center, my request would be to lay some emphasis on mediation as well, because just see I need not emphasize the importance of dispute resolution through mediation process. In the arbitration, ultimately, the one party wins, the other party loses. And then the chances of the matter being taken up further in an appeal or in an SLP, that still remains. But mediation, it's a win-win situation for both the parties. So that emphasis should be given to the mediation process. And I understand now that with the introduction of the pre-litigation mediation, not only in the Commercial Court Act, I personally feel that Section 89 of the CPC has yet not been, utilized to its fullest potential. If you read Section 89 of this Code of Civil Procedure, as interpreted by the Honorable Supreme Court in FCON's case, the first step to be taken by a court where a suit is instituted is to refer the matter for either of the ADR processes. The potential of Section 89 has yet not been utilized, but with the advent of new statutory regime of mediation, I hope and I have a feeling that the emphasis of ADR systems is now going to shift from perhaps arbitration to mediation. So I would request the Bombay Center to work in this area as well. So today, I feel glad to be amongst all of you, and I wish all success to this center and hope that this center as an institutional mediation center, as an institutional arbitration center, shall set up an example which can be followed by the rest of the country. Thank you very much. I must tell about Justice Bhosle. He is a great fan of mediation process.
I'm here for two things. One, for personal apologies to the former Chief Justice of Allahabad High Court and Andhra High Court, my Lord Justice Dilip Bhosle. I forgot to mention him in the introduction. My personal apologies, sir. Of course, taking a clue from what the Honorable Chief Justice said, I think no one in this room would agree anything lesser. So this is notwithstanding Section 12A in the Commercial Courts Act and Section 89, as you said, sir. This is going to be a watershed moment, this new act, and we at the center are going to take it seriously. I will, however, reserve that prerogative to Madhukeshwar and to Neeti to elaborate a little more on that. But as a center, this is now certainly going to be a very big area of focus for us. Thank you, Your Lordship. Thank you for your words of wisdom and advice.
Thank you so much, sirs, for those inspiring words. And with that, we bring to a close the Mumbai chapter of the India ADR Week 2023. And all that stands between us now and the cocktails and the dinner is the vote of thanks. So may I please request Shreya Aren, co-chair of the Young MCIA Committee, to come up to the stage and give the vote of thanks.
Thank you, Honorable Chief Justice Upadhyaya, for your very insightful and articulate words today. It's a real honor to be giving this vote of thanks, especially because I share the home state of Uttar Pradesh with you. So it's actually a real honor for me. And I think we should all take to heart the call to action that you made to make business easier, especially to bolster the economic progress of India, and to not just think about arbitration when we're thinking about ADR. So thank you for providing a real overview of the Cutting Edge Mediation Act 2023. And I hope Madhukeshwar and Neeti are ready to start a separate branch of mediation with the MCIA. Thank you very much, everyone, especially the sponsors for making this event the success that it has been. I understand dinner has been served, so please let's all proceed for that. Thank you very much.